It is 6:30, and I'm going to call the Charter Review Commission meeting to order. The date is Monday, February 10th, 2025. First up is roll call. I'll start on the right end over here on my right. Commissioner Ford,
Here.
Commissioner Knight,
Here.
Commissioner Walsh, Commissioner McCutcheon, Commissioner Glicker,
Here.
Commissioner Kirkwood.
Present.
Okay, a quorum is established. Moving on to item number 2, approval of minutes. Did everyone have a chance to review the charter review minutes from January 27th? Do we have any corrections or comments? None? Do I hear a motion?
Make a motion to pass last week's minutes.
Okay. we
I'll
have a
second
motion. A motion to approve, a second by Commissioner Kirkwood. All in favor, say aye. Aye. Okay. Motion passes 5-0. And then moving on to item number 3, citizen comment period with the Charter Review Commission. Do we have any citizens that would like to speak? Seeing none, I'm going to move on to item number 4, staff reports and presentations. Receive a report and hold a discussion, provide staff feedback on review of the potential recommended changes to Articles 1, 2, and 3 of the city charter. First up is Amy.
Good evening, Madam Chair, members of the commission. Amy Alcorn Reed, City Attorney, for the record. So what I've kind of done is just put together some information about each of the articles of the charter, and then I've highlighted a few provisions that I think the commission might want to look at a little closer. So this is Article 1. I'm not going to read down this, but it gives you an idea. Article 1 is pretty standard. This is how we form a city stuff. I did make note that the form of government is council manager, and so if anyone has questions about how that works, we can discuss it. And then otherwise, the provision I've pointed out for potential further discussion is 1.07, but if there are any other provisions that the commission would like to discuss first, we could do that.
Hold on. Okay. Does anybody have any comments on, you were looking at section 107, is that right?
1.07 is the other one that I've pointed out.
Okay, section 107. Does anyone have any comments or corrections that need to be made for sections 101, 102, 103, 104, 105, and 106? Commissioner
Yes.
Knight.
I have 104.
104.
It is general powers of the city.
And also questions about 106
Okay,
and 108.
104, 106, 108. All right. What's your first comment on 104? Let's go in order.
104A. And I really don't have a problem about this, other than grammatical errors. But it's to provide for the advancement of the interest, welfare, health, morals, comfort, safety, economic well-being, or convenience of the city, blah, blah, blah. I'm not sure what the definition of morals is.
I don't believe there is one in the
Okay,
charter.
then I'm not sure I like that. I mean, I'm not going to go there. I'm not sure that our city's charter should be setting forth the morals of the city. I mean, understand that could be like, prostitution or,
Crimes that are typically considered of moral turpitude.
Right, but we also have safety and well-being, and I think that a lot of those terms encompass morals.
I don't know the history on the use of the word morals in this provision. We could look into that if you
Okay.
would like us to, and see if we can find any times that it might have been discussed previously.
Yeah, I'm sorry to be a stickler, but for me, the meaning of words matter.
Okay, did anybody else have any comments in regards to section 104, 101, 102, 103, or 104 before we move forward? No?
Yes,
Oh,
okay, 104C,
oh,
and it's about contracts. I mean, I guess it's okay, but it seems kind of vague.
So my reading of this provision is that it essentially incorporates the Texas Interlocal Cooperation Act, which allows the city to contract with other government entities in order to perform a government function, and then it also authorizes contracting with persons, firms, or entities. I'm not sure what might be missing or need to be
Well,
removed.
I guess my concern is if the city enters into a contract with another person, firm, or legal entity, what takes precedence, the charter or the contract?
All contracts must comply with the charter.
Okay, I'm good with that then.
okay, any other comments?
Just
Commissioner Ford?
a consistency issue with wordage specifically in section 104A. It lists the comfort, safety, economic well-being, or convenience of the city and its inhabitants versus section 105, where it discusses ordinances for the welfare, comfort, quality, and life of the city and its citizens. There is a pretty key difference between inhabitants and citizens. We should pick one and be consistent.
There's actually a lot of discussion kind of more in the general government realm on the use of the word citizens in charters and contracts and ordinances, because the suggestion is that it applies only to U.S. citizens as opposed to residents of the city that may or may not be U.S. citizens. A lot of cities have moved to residents. There's no, I have no personal preference on how you guys want to suggest wording it. But in this instance, I do see that there's an inconsistency there. In some places it might be inhabitants, in some places it might be residents.
There is a pretty big difference between the three of them. So I think it's pretty important that we find the word that fits best and use it consistently across documentation.
I agree, my cat is an inhabitant.
Whereas you're a resident. Your cat is an inhabitant and you're a
Well, he
resident.
can't vote.
Yeah.
He's an inhabitant.
Okay,
It's something we can look into, and that would be kind of throughout the whole charter to make sure that we're using terms consistently.
okay. Any other comments in regards to section 104?
Yes.
Uh-oh.
No, it's section 106, power of eminent domain.
I said 104.
Oh, sorry. Was it?
Anybody else? Okay. Section 105. Seeing none? Moving on to section 106. Commissioner Knight.
Yes, I have a concern only because the state of Texas, well, no, wait, hang on, let me look. The state of Texas has made so many changes. Are we still in compliance with that?
So, and I pointed out the same issue on 107. I can bring that out. The state has made a lot of changes in the past decade or decades.
Yeah.
Both these provisions do contain language saying that it's that we have the power of eminent domain and the power of annexation when not inconsistent with state law or as permitted by state law. So to the extent that anything currently conflicts with state law, I would argue that the state law already controls. But I do see, especially in 107, it's a lot of language, and so perhaps some of it's superfluous, and we might want to change it.
Doesn't state law supersede?
That's correct. There's multiple provisions in the charter that say, as allowed by state law, the city as a home rule municipality We can do anything that the state doesn't specifically prohibit us from doing or hasn't already done. But if the state has already said you can only do it in these instances, then that's the only times we can do it.
Anybody else have any other comments in regards to section 106? No?
No,
Okay, moving on to 107.
So I said that's the same issue. I pointed that out. The state law on annexation particularly has changed quite a lot. Pretty much every legislative session, there's been a change on annexation or ETJ authority. So my argument on 107, it's very long, but it does specifically reference that it can only be applied in a manner consistent with state law. So if any part of it is inconsistent with state law, the state law will control. But it's possible that perhaps this commission would like to consider simplifying this language and basically pointing to the state law as the city can annex and disannex in accordance with state law, or whatever language you might think would be appropriate to remove.
Well, I think it's, so you would just rule out the, not give the detail?
It's not up to me, it's just an option.
Okay.
There's just a lot of language in here, and there's potential for it to be confusing and wordy. So I don't know if we want to keep it that way, if we want to change some of the language to be consistent with the current state law, knowing that the state law is likely going to change again, or if we want to leave it alone and understand that the state law controls.
Commissioner Knight?
well, my concern is and it does say absent procedures established by state law, and then it goes into a lot of detail about public hearings and public notices and all of that. And I believe that probably is defined in state law. And I don't know if what we have here currently coincides with what state law says or not. Sorry, didn't look it up.
I would imagine that most of it does, except when it talks about unilateral annexation, which in most instances is no longer allowed in the state of Texas.
Ooh, but it says we can unilaterally annex.
Yes, in most instances, we can no longer unilaterally annex. So most annexations now are done by petition of the landowner.
Would the city attorney have any alternative language to this very long paragraph?
The shortest way to do it would be to say that the city has full power to annex and disannex in accordance with state law. That'd be the simplest way to do it, if that's what we're looking for. If you want, I can go pull the exact statute and we can copy that instead. Or like I said, we can leave this alone. It's up to the commission, however they want to recommend it.
I mean, the state could change it this year.
Yes, they're in legislative session right now.
The only argument I would have is if I was a resident, inhabitant, citizen, where would I look? I would look on the city website to the charter, not necessarily looking for state law unless the URL is going to be there or whatever.
Could we cite the state law?
Well, the risk of that is they renumber, they move it to a different code.
Okay.
I mean, the Cliff Notes.
I think it's important to include the language that talks about notifying the public on hearings. The only thing that I would perhaps update is the fact that it says notice of such public hearings are published in a newspaper of general circulation throughout the city. That's not especially relevant anymore. Is there a more effective, efficient way to communicate with the public aside from newspapers
So
today?
the state does still require us to publish notices in the newspaper.
That's state law.
That's still state law. We do also, of course, post our agendas on the city's website where people can find them. I'm not sure of another alternative method to providing notice, as the state has pretty much said you have to put it in the newspaper. except in some instances where they require us to mail it to people's homes.
I'm sorry.
Commissioner Knight.
What about using the term unilaterally, if that's no longer allowed? In sentence 1.
So I would prefer not to just make that change, because if, say, the state ever changes it and now there's an instance where it could be done, or for the few exceptions in which we still can annex unilaterally, now we're providing additional limitations on the city that the state does not provide. There are still a few instances.
Okay, but at the end of this sentence, it says, as authorized by applicable law. Should that say state law?
It can. This provision references state law at least 2 other places.
I mean, I think we need some consistency there, because law could be a city ordinance.
Okay.
Commissioner Walsh.
Under what circumstances can we still unilaterally annex anything? Since what I've seen in the news and stuff, it pretty much, threw it out. I know that Buda's had their problems with persimmon.
That's
and,
correct. Yeah, there are very few exceptions. There's one that's used regularly in more industrial areas, but there are not very many exceptions left.
All right, thank you.
So do we want to go to the short version or just leave it alone? Commissioner Kirkland.
I like the short version.
I agree.
I'll go for short.
Short.
Short works, but which short version? Are we going with the single sentence, or should we take a little bit more time with this?
We would have time to reconsider that. We can bring you proposed language and you can tweak it as we go along.
I like that option better.
I mean, I would at least like it to say what's going to happen in what time frame and or
To the extent that we can.
that you can, yeah. Because I would think some residents don't have access to different things, and they're only going to look at the city website or come and ask Jennifer or something. I don't know. Okay,
We can bring you some proposed language at the next meeting to look at on that.
okay. All right. Moving on to section 108, streets and public property. Commissioner Knight?
In the first sentence, it does say we have exclusive dominion control jurisdiction, but it includes the word highways. That could be a state highway, and I'm pretty certain we don't have exclusive dominion control and jurisdiction over those.
Highways is very broadly defined in
We
various
don't
parts
have
of state law.
definitions. We don't have
Well,
definitions.
I know,
in
but the
this.
common understanding in Texas of highway has been defined in multiple ways, and one of them is like your standard street, so it's kind of complicated to deal with the word highway.
Can we just omit that, and then there would be no confusion?
I-
What about county roads?
Right.
I wouldn't omit it. What about 1626? Or
That's a state highway.
what about Colors?
That's a county road. Well, it was a county road. I think it's ours now.
It's ours now. What about part of Windy Hills is ours? And by the time that's done, it's going to be 5 lanes, 4 lanes, whatever. That's a highway.
And we
Yeah, but-
often have
But it's
some,
also considered a public street.
right.
So we don't really need the term highway, which is obviously very vague.
Commissioner Glicker.
Under the Texas Transportation Code, the definition of highway or street means the width between the boundary lines of a publicly maintained way, any part of which is open to the public for vehicular travel.
Right. It's a broad definition. It's basically defined as the same thing.
Right.
Well, if
And I
that's
do
the-
think we have some, we don't have exclusive jurisdiction over highways, but we do have some jurisdiction of things that happen in the city, whether they happen on a highway or a street. And so I think that's, taking it out might suggest we don't have any jurisdiction on highways, and we still would. Just wouldn't be exclusive.
Anybody have an opinion of taking it out?
I still think it's overreaching.
I think it's, I say stay.
Commissioner Kirkwood?
I'm sorry, what are we taking out? The word highway?
Yeah.
I'm okay with leaving it. But we're given that broad definition. I mean,
Commissioner Glicker?
I'm in favor of leaving it since it is defined in the statutes.
Commissioner Ford?
I have no problem leaving it the way it is.
Commissioner Nine?
I'm a no.
I'm in favor of leaving it. All right. That's section 1.
Is that everything we have on Article 1? Article 2 is very, very short. It's a single provision. And it also specifically references 1.07, so perhaps we want to take a similar action on this one as we did with 1.07.
I don't see any verbiage about unilateral.
It doesn't have as much verbiage. It just says, you know,
See also section 1.07.
right. My recommendation, honestly, is to just leave this one alone because it references 1.07, and if we're going to make the changes in 1.07, those will be referenced here.
Anybody else feel differently? Okay. Moving on to section 3.
Article 3 is a little bit meatier. So this one I assume will take a little bit longer. You'll notice that I have specifically called out almost all of the sections of Article 3, except for 3.01 and 3.07 and 3.05 apparently, but the rest of them are on my list. I could ask if anyone has changes they want to recommend to 3.01 before I move on to 3.02. It looks like Ms. Knight does.
Commissioner Knight?
Yes. I know that the city is currently studying a potential redistricting of the city, and we don't know what that will be. And it specifically says here in 3.01 that 2, 4, and 6 shall be elected from single-member districts.
So under the current charter, our redistricting plan is redrawing 2, 4, and 6. It is not touching anything else.
I don't know that for a fact. I mean, in terms of.
They can't approve anything else because this is what's in the charter. So any other configuration would require a charter amendment. So it will redraw 2, 4, and 6, but it cannot add another district without a charter election.
Can they merge districts? I mean, can all districts be voted citywide?
Not without a charter amendment.
Okay, I'm good with it.
You would prefer to have everybody be at large? No, okay. You're good with leaving it as it is?
Yes.
Okay.
Anybody have changes to section 3.01? No. Okay. Moving to section 3.02.
So 3.02 I have pointed out because our provision is less flexible than state law. And so when I saw something that was less flexible than state law, I wanted to point it out to allow the commission the opportunity to review it. In this instance, our provision says that no candidate for council shall hold other elective public office. So there are rules under the state constitution that require people who hold public office and want to run for another public office to resign in certain circumstances, which is if there's more than 1 year and 30 days left on your term. So if I'm a county commissioner and I have more than 1 year and 30 days left on my term, but I want to run for city council, then I have to resign. But under state law, if I'm a county commissioner and I want to run for city council and I have less than 1 year and 30 days on my term, I don't have to resign. But under our charter, I still would. And so that's less flexibility.
Commissioner Knight?
I actually don't have a problem with the way it's stated right now, because there's a difference between a state or county office and city council.
Right.
I do have a problem where it says, no candidate for a member of the council shall hold any other elected public office, because there actually are constitutional exceptions.
Okay.
And I mean, I think it would be a fairly easy fix. Any other elected public office, except per the state constitution. I mean, the exceptions are very bizarre. Okay, but just to be consistent.
But you're okay with having less than a year and 30 days and still having to resign?
I like it the way it is.
Okay.
So what are the exceptions?
Commissioner Knight?
Okay, so if you're on this city council, you can actually be a municipal judge in another city. That's one example.
That is usually not elected, though. That's usually appointed.
Okay.
Another example would be, say you're a commissioner for an ESD, an emergency services district. You cannot serve as a city council member.
I'm trying to think of an exception in which both offices are elected, and I'm having trouble. I can think of appointed and elected. I can't think of both being elected off the top of
Okay.
my head. It's possible there are some, but I can't think of one off the top of my head. There is a pretty strict doctrine of incompatibility, so you can't hold two offices if they're incompatible with each other, and you can't hold two offices of emolument. So those are pretty standard for the most part. But in order to hold an office, your office has to be a little bit sovereign. So if you're a municipal court judge, but you're also maybe you're a municipal court judge in multiple cities, that's usually allowed. But if you're, a mayor and a county commissioner, that's never going to be allowed because those are in conflict with each other.
Commissioner Goodell?
I mean, we have one example right here in Kyle. Our municipal judge is Andy Cable, who is the elected justice of the peace over in Wimberley. So,
Right. But he's appointed here.
right, but he's appointed here. Municipal judges are by appointment and whatnot. So, I personally think that we should track the state constitution and add language that follows the more than 1 year and 30 days left. That's
Okay.
because I think that as much as possible, if we're tracking the state constitution, it allows us the flexibility going forward when the legislature does their thing.
Anybody else have any other comments?
This is just a efficiency thing from a language standpoint. There's verbiage in here that states things like his, her office shall, upon fact, the member shall serve the remainder of his or her term of office. I think if we include language such as them or they, it's fairly all-encompassing, and it shortens it just a little bit.
That's another one of those legal writing things that has gone back and forth in the last few years as to whether it should be his is the gender neutral his, which was traditionally the way that things were done a long, long time ago, versus his, her, versus they. It kind of goes back and forth which one they want to use.
That's my personal preference, is to use they or them. It is all-encompassing. There's no need to.
It does seem to be inconsistent because it says like having residence for the office which they seek, but then somewhere else it says his, her office. And so it does seem to be inconsistent in this own paragraph.
Any others? Okay. All right, moving on to section 3.03, term limits.
The reason I brought up term limits, and there are probably lots of other reasons to talk about it, is that the provision does specifically allow a council member who has served 3 consecutive terms to run for mayor. It neither specifically allows nor specifically prohibits a mayor who has served for 3 terms from running for council again. So because it's not in there, someone may argue that it's prohibited because we've specifically pointed out one but not the other, but it's not specifically prohibited. So this is potentially confusing and something that could potentially have to go to a court for a determination if, say, a mayor wanted to do that. So my suggestion is to clarify it and say whether we want to allow it or not.
I was actually on council when we added this provision. I don't think it was added before that. Commissioner Knight?
Well, regardless, there's at least one, one office that might serve as much as 18 consecutive years, and that seems a lot. Maybe we should just clarify it by saying 3 consecutive terms, period. Although you can lay off a year and then come back. I think 9 years is more than sufficient.
There are a lot of different ways that cities do these. Some of them will do, 3 terms as council, 3 terms as mayor, or 5 terms in any combination thereof, or something along those lines. It just depends on how you as the body want to recommend it to council. My main purpose of bringing this up was to avoid a unanswered question.
Any thoughts down here?
Yeah, I see the exact point you're making, and I think that it should be consistent. And it would be easily done by tacking provided that a person, half of the first sentence be duplicated, exchange the terms council member and mayor, and added to that sentence.
Okay, I just want to bring up in theory, a person could go back and forth between council and mayor forever if you do that. So just,
Yeah,
just
we're
be
not gonna-
aware of
we're not
that.
going that route.
I would also add that
6 terms total, basically.
yes, no person may serve more than 6 terms total as council member and or mayor.
6 consecutive terms.
Consecutive.
They can come back later. Yeah.
I think that's 18 years.
I don't think that they should come back after 18
He's
years.
saying 3 councilmen, 3 mayors. He's saying 6 terms, no?
That's 18
That's
years.
18 years.
Each term is 3
Oh,
years.
that's right, you're correct.
That's 18
I like
years.
the 5. I like the
There's
3.
plenty of that.
3 as a council and then 2 as a mayor.
So
or-
basically 3 at each or 5 at any combination thereof. Something along those lines. Consecutively.
I like the 3 consecutive terms, both for council and mayor. Commissioner Knight?
I think 3 consecutive terms is enough. You lay off a year, and then you can come back and run for whatever you want for another 9 years.
I agree.
So,
I mean, I'm not trying to chop the
yeah,
charter up, but I do agree. If you've served 9 years, you should have to take a year off, whether it's council member or mayor.
you need a vacation.
Well, and if you wanted to come back for a
So the
10th year, you'd
suggested
be
language
crazy.
would be 3 consecutive terms either as mayor or council member.
Yeah.
In any combination thereof.
I can get behind that.
For a maximum of 3 consecutive terms.
Right.
And do we want to spell out clearly that any person term limited out from running for reelection is eligible to return after?
I think consecutive does that.
Okay.
Again, I've seen different cities do this different ways. Some of them make them rest more than 1 term. Some of them just say sit out for a year and run again. It just depends on what the residents want in their charter.
And we could really simplify it by just saying for 3 consecutive regular terms regardless of office.
Yeah, I'll wordsmith that and we'll come up with something.
Okay.
Any other suggestions on section 3.03? No? Okay.
3.04, vacancies in office. Again, this one provides us less flexibility than the state law. Because our council members serve for more than 2 years, if there's a vacancy, they typically do have to be replaced by election within 120 days. However, the state law does allow a municipality to provide for an alternative method in the charter if the term that expires is less than 12 months. And the reason this is important, at least from my perspective, is that if we have a council member who resigns 124 days before the end of their term, we are required under this charter to hold an election before the general election. So we have to hold an election because we have to hold it within 120 days. And then 4 days later, they have the election anyway. So that the person who won the special election wouldn't actually get to serve. But we're still required to hold it under the charter. So I'm looking for some more flexibility in that last year so that we're not holding an election for the same office twice in a year.
Yeah.
Now, different cities do it different ways. The best example, or at least the most similar example I found is Buda. Buda requires the election within 120 days unless there's less than a year left on your term, in which case they allow the city council to appoint a replacement for the rest of that year.
Commissioner Knight.
I am absolutely opposed to the city council appointing one of their own.
Okay?
It has to be an election.
Would you rather leave it vacant if it was
Yes.
in that situation where,
Yes.
where it was close to the 120 days?
Well, the example you gave was like 124 versus 120.
Right. I was trying to use an extreme example to explain why it's a problem. Because technically that's what it says and we have to comply with the charter. And
But
it's more likely to be like 160 days, but still, it's problematic to have an election 30 days before the actual election.
I think we would like lose one for like 3 or 4 months and not notice.
Did you run into any other examples besides Buda?
I haven't found any that have a different election timeline during that year. Now, we could do that. We could say if there's less than a year left in the term, you have to hold an election within, say, 6 months. Or on the next available uniform election day, whenever that happens to fall, if it's within the year.
It's not like we leave those people in that district, if it's a fixed district. It's not like we leave them without a councilman. They still have 3 councilmen and the mayor if they pay attention to what they're doing. They still have a voice. So you may be right on that one.
And my concern is if the council appoints someone as an interim city council person, that's giving them a leg up to be elected.
I'm not in favor of the council appointing either, but I just want a clarifying question. Are there rules around how they would appoint this individual, or is it just left up to them to say, hey, we want Billy Bob to serve the rest of the term, or?
That would be up to the jurisdiction. So I have experienced a council who appoints their own replacements when this happened in my previous city, and they had rules in place. They took applications, they interviewed the candidates, and then they appointed one.
Okay. All right, thank you.
I'm just asking, is popping it through my head, is there any way to coordinate this with the ethics committee screening applicants for appointment as opposed to it just being ad hoc city council? I don't know if that's something that could be done or looked into.
I don't see why it couldn't be done in the charter if that's the way we wrote it.
Because what I'm thinking, I'm thinking in terms of my past experience when the road naming issue became a very big issue. They ended up creating a special committee, and we were appointed to take care of the road naming and take it out of the hands of city council. I don't know if we could toss that to the ethics commission or not, but I mean, if we could incorporate a way to get it done so it's not just the council members choosing.
Or similar to the council compensation committee, have the council appoint a committee to consider candidates and make a recommendation.
Commissioner Knight.
I'm concerned about kicking it to the Ethics Commission, because number one, that's not what they do in ordinance. And also, each council member appoints their own people to the Ethics Commission. So it's almost like parallel to, the city council. And, I mean, if we needed to come up with some sort of like other committee, like a council compensation committee, I would prefer to do a committee by lottery.
Oh, my God.
Let's make
So,
it as complicated as we
I'm not
can.
sure that the appointment process is popular. So the other suggestions I would have would be to say if the vacancy occurs with fewer than 12 months remaining on the term, that the next election will be held on the next uniform election date, whenever that falls. So that we're not being forced to hold hold a special election before a general election in 3 or 4 months.
And just leave the office vacant.
Yeah, it would just stay vacant. We'd hold an election we'd hold an election on or before the next general election date, whenever that should fall.
I like that, and I can tell you, I lived in Buda for a few years, and there was a stretch there where we had some kind of a city council election every 90 to 120 days. You know, there was an open spot for mayor, and people ran, and a council member got it, and then there was a runoff, and then another person resigned, and it just got election fatigue. And so the more elections we have, the more turnout goes down. So I'm in favor of anything that reduces the number of our elections.
I don't disagree with that, but also in Buda, there was a question as to whether or not some of the council members, because when they did change the charter, as to whether or not they were appointing people who, to Commissioner Knight's point, would give a leg up as to who they wanted on council. So, I'm fine with leaving it vacant.
Okay, and just having the election on the next general election date.
I'm in favor of that.
Okay.
Any comments down there, Commissioner Ford?
No, I'm in favor of leaving it vacant.
Okay.
So we're gonna go with the state verbiage where, anything over 1 year and 30 days.
It's,
we have
12
to have
months
an
on this
election.
one.
We'll just go with the state verbiage, or will we leave the 120 days?
So it's 120 days unless the unexpired term is 12 months or less, in which case it will be held on the next general election date,
Okay.
next uniform election date, whenever that occurs.
All right. Yeah, I'm good with leaving it vacant. We have enough people.
Okay. Moving on to section 3.05.
Oh, I didn't point that one out. Does anyone have comments on 3.05?
Commissioner Knight?
We're on 3.05, right?
Yeah. I just don't have anything on that one.
Oh, okay. What, I have to think for myself? You know, I do believe this is a good section. I've just never witnessed it to work.
My only comment is the verbiage that says, shall have the power to compel the attendance of absent members and to punish members for disorderly conduct. What does that mean? What does that look like?
Typically, in a governing body, that would be sanctions. But
It's not spelled out clearly, and it can be twisted many different ways.
And you'll see I've pointed out kind of a similar issue in 3.06, that something constitutes misconduct in office. And so that's basically what it would be. It would be the council finding that a member committed misconduct or putting sanctions against them or.
I think the chair is like purposely avoiding me.
I'm sorry, Commissioner Knight.
I've witnessed a couple of times where there have been serious ethics violations that have gone to the Ethics Commission, and then they went to the City Council, and no action was taken. And that included City Council members owing past due taxes. So, as much as I like this paragraph, and as much as I think we need it, I think it's like entirely ineffective.
Okay, do you have a suggestion for how you'd like to make it more effective?
I know as an HOA board member, I have to have all my dues paid before I can serve.
I believe we verify that on candidates, that they don't owe city taxes or. When a
Utility
candidate
bills?
runs for office, we verify that they don't owe any taxes or utility bills. Yeah, we do verify that on candidates.
Okay, once they're elected, is there any kind of follow-up on it, or no?
No, it's to run for office. Like you said with the HOA, it's a requirement to run, that
Okay.
you don't owe any indebtedness to the city.
Oh, it's a requirement for me to continue to serve,
Okay.
so that's the first thing that would come out. So, anyway.
The only thing I can think of is to like put in some sort of reference to ethics complaints. Because I know when this was first written, we did not have an ethics ordinance.
Well, that's,
Okay. If you want to think about maybe some suggestions, you can either send them to me between the meeting or we can talk about them next week.
Yeah,
Next
maybe
meeting.
so.
okay,
So,
we-
I'm sorry.
Commissioner Kirkland.
I may have missed this, but looking back at the qualifications, I guess if you're a convicted felon, you can still you can still run for city council?
You can be president.
Okay, why don't we?
I would have to check the state law on that one.
Okay, because it doesn't, reading through this, and I've read it through it once, I didn't see anything about convictions in 3.02 qualifications. So, I guess.
I don't have the state law on that one handy off the top
And
of
I
my
guess
head.
maybe Commissioner Knight was stating that kind of take it out of the hands of the council members and put it in the hands of the ethics board to remove me when I've done something.
I don't know that we can do that.
Okay,
We can recommend, ethics commission make recommendations to the council, but that's really as far as the ethics commission can go.
okay. Because it just says they have the power to remove. Doesn't mean that if I go and
No.
get convicted for a felony, that that's an automatic,
Removal, no. I mean,
Removal,
the
it's-
residents have the power of recall, and so there's always that option
yeah,
if,
but that's, yeah,
if the
okay.
city council doesn't take the action.
sure.
But if it's in the charter that the Ethics Commission can make at least a recommendation to city council, or even remove city council,
I'm gonna
if
have
it's
to
in the
research the
charter,
state
then
law on
that
that.
makes it different, right?
I'm gonna have to research the state law on that. Typically, a governing body is the only body that can remove members of the governing body.
Okay.
So I'm gonna have to research that one. I can't say off the top of my head if that would be allowed or not.
But could it be stated that they shall remove for certain instances, like a felony conviction, they shall be removed? There is no, well, we like Bob, so we're gonna keep Bob around.
Okay, but
even
what if
though-
their conviction is currently under appeal?
Then it's not a final.
Then it's not.
Then it's not a final conviction.
Right.
And under the Texas Election Code for candidates, eligibility for public office does specifically say that final conviction of a felony would disqualify you from any public
I-
office.
Yeah,
My
but-
problem being if they commit the felony while in office,
Sure.
they have their trial, they're convicted, and they still
They
appeal. I
can-
mean, we're looking at like a 3-year term. To get through an appeal, it's probably gonna take longer
They're
than that.
sitting, yeah, you're right, you're right.
That's how the law works.
Great,
Okay.
they can continue stealing from us.
Okay, so.
It's true, because if they miss, 3 meetings, they constitute misconduct in office, which is the next provision.
Say that again?
This is 3.06. The reason I pointed out 3.06 is because what 3.06 says at the end is that if a council member misses 3 consecutive council meetings, it'll constitute misconduct in office. And so sometimes we have 3 consecutive council meetings on the same day,
Yes.
and so that seems a little bit difficult to me.
But doesn't the term legitimate reason,
Yeah, without good cause,
Negate that?
without good or sufficient cause, but then that leaves council to judge what's good and sufficient cause. So if you're a council member who maybe isn't popular among other council members, they may decide that your good and sufficient cause isn't good and sufficient to them.
I talked that over with a friend of mine today, and he was thinking, well, it looks like it's good enough, but that was my thought with him, that it would be, if it was somebody they really wanted gone, they'd be gone. Because they would not take any legitimate, or any what you and I would consider legitimate, they could override it.
And I do think there is some gray area on what is good and sufficient cause. I mean, I think my example might be a little too extreme because probably a car accident on the way to the council meeting is going to be considered good and sufficient cause by most people. That's the example I gave. But what if it's, birth of a grandchild? Is that good and sufficient cause to everybody? Or is that good and sufficient cause to some people? I think 3 consecutive meetings on the same day is problematic. I think if it's 3 consecutive meetings across multiple weeks or multiple days, it would be a little bit more forgiving of a family emergency or a single instance.
Commissioner Knight.
according to this, it takes 6 affirmative votes of the council to remove a person. It only takes 5 to remove the city manager. And I'm assuming that the council member in question would not vote. Although I'm not sure, because it doesn't state that one way or the other. Maybe we could reduce it to 5 affirmative votes.
Is that in 3.05?
Yes.
Okay. Yeah, we could reduce that to either a majority of council or 5 votes as opposed to 6. We could make that recommendation. I think that's a reasonable recommendation.
I just want to point this out. I'm really raising it because I don't have a strong feeling either way. But I mean, the difference would be this: the city manager is an appointed position. So to decide to remove a city manager is to decide to remove an appointee. Whereas to decide to remove a council member is overriding the will of the voters. So, I mean, I can see a distinction why the number would be different for that reason.
I can too. It's just hard. It's hard to do. I also see Ms. Knight's point because it's hard to say every single person's going to vote that way. And you're right, the council member involved is not going to vote. And so then it's everybody else has to vote for it. So 5 could be, you only have 1 dissenter, but you still have a supermajority of council because 5 is still a supermajority of the council. But that's just understanding the logic. Whatever recommendations the commission makes, that's fully up to the commission.
Do we want to go with 5?
Works for me.
Commissioner Glicker?
I'm fine with that.
Walsh?
5 works for me.
Mike?
I would vote for 5 affirmative votes.
Commissioner Ford?
5 works.
All right, are we on section 306 or?
306.
Okay.
I think we jumped back. We were on 306.
I would request some proposed language to add at the end of that that clarifies that 3 consecutive meetings must be on 3 separate days regardless of how many meetings were missed in a single day.
Yeah.
Because I think at that point, you'll know the difference between someone who has consistently good and sufficient cause to miss meetings and someone who's just not doing the job.
Well, I'll give you an example. When I was on council, I lost my dad. And we had a lot going on, and I missed 3 consecutive meetings because I had to travel all the way to Pittsburgh and then come back. So, but luckily I had a council that excused it. But instances like that, you can easily come to a situation that maybe a council member might miss 3 consecutive meetings.
Or another example for what could be considered not good and sufficient cause is, say you have a pre-planned vacation, and while you're on your pre-planned vacation, we call special meetings that you weren't aware of when you planned the vacation. So you tried to plan your vacations around the council meetings, but now we've added special meetings that week. And is it good and sufficient cause that you pre-planned the vacation, or should you have to cancel the vacation? That leaves kind of a question mark in my head.
I would give an option where, or add something that if council excuses the absence.
Okay. Without excuse from council.
And I'd also like to point out that over the course of the last few years, now twice a month, we have both a special and a regular meeting on the same day, which is 2 meetings on one day.
Right, and that's why I pointed it out, because when we canvassed the election in December
Right.
or November,
That's
we
right.
had 3 on the same day. We had a canvass, a special meeting, and a regular meeting all on the same day.
Understood.
I am absolutely in favor of adding language that sort of extends a little more grace, some clarifying points, extended illness, especially in the case of COVID or anything like that. I think we just need to honor the humanity of our council a little bit more.
Okay. It sounded like the 3 different days might be a suggestion. I can work on some options.
Okay.
I'm not, I'm not opposed to the idea of having a non-exclusive list of examples of good and sufficient cause. You know, whether it's a definition or just a sentence that says something to the effect of, you know, examples of good and sufficient cause include blah, 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 or other such
Similar. Yeah.
similar reasons, something to that effect, just to make it, you know, provide a little bit more guidance to the city council.
We can work on a couple options to look at on that one.
Okay. All right, section,
3.07 is also not on my list. That's about meetings.
anybody have anything in regards to section 307 before we move to 308? No? Okay. Good. Section 308, voting.
So I pointed this out because it seems to have some inconsistency internally in it, or at least some unnecessary language. The way 3.08 is written, it says that a quorum is a majority of the council, and that typically the council can act by majority votes of the council members present, but then it says not less than 4 affirmative votes are required to pass or approve an action, an ordinance, a resolution, a matter, an issue, or a motion. And so that seems to cover just about everything the council does requires 4 votes. So then the language regarding a vote of a majority of the people present doesn't seem necessary.
This one had jumped out to me as well, and I pondered over it for a little bit. Could we force a table on a vote for an item like that?
You could, what I've seen in other cities looking at other charters is that some types of action will require 4 affirmative votes or whatever the quorum number of that council is in affirmative votes, and other actions will not. Like maybe a motion is just the majority of council, or maybe a motion is just the majority of those present, whereas an ordinance and a resolution would be a majority total, would be the 4 affirmative votes. I've also just seen every action requires that number of affirmative votes, and that's fine. But then if you end up in a situation where you only have 4 people present or 5 people present and you can't get to 4 affirmative votes, you do have to table the item and bring it back when you have a tiebreaker, which is okay.
That's what I'd like to have happen. I'd like to have it tabled for the next meeting, or
So you want every item to require 4 affirmative votes? That's
Yes,
currently how
I'd
we
like to
practice.
I'd like to stay with a majority, you know, I'd like to stay with a majority, so if they don't have a majority of the council, even if they've got majority of the quorum, okay, you got 3 people that vote for something that's very unpopular, because 3 people are absent,
And that's the risk.
yeah, so.
So you're making a motion to table this until our next meeting?
No, I'm saying if they
Oh,
run into
okay.
this situation where they only have 4 council members here, and this specifies they have to have four affirmative votes to pass anything, and you get a 3-1 split, I'm saying they need to table that to the next meeting, to when they have a larger group or whatever.
Get you guys to show up.
Pardon?
Get your guys to show up.
I kind of like what Commissioner Walsh is saying, because if there's if there's a full council, it takes 4 votes to pass anything.
Yeah, it does.
So in his example, it'd be 4, or otherwise table it.
So it would just be every item would require 4 affirmative votes.
I like that.
I concur.
I do as well. Commissioner Knight and Ford?
4.
4.
Okay.
Can we back up to 3.07 meetings?
Yes.
Okay?
The last sentence says, "The mayor or city manager shall approve meeting agendas, and a council member may require any item related to city business to be placed on an agenda for which notice may be given." And I'm not sure that's how our rules of council read, but I don't have them in front of me.
The rules of council place a little bit of limitation on how an item gets put on the agenda, yes. But
No,
a single council member can add an item to the agenda currently.
No, but this sentence is in our charter, and it specifically addresses how something is placed on an agenda.
This says that a council member can place any item related to city business on the agenda. The rules of council provide how an item can be placed on the agenda. It's a
No.
procedural option.
You're cutting hairs.
But she's not, council is.
No, I think that either this needs to like comply with the rules of city council, or the city council should comply with the rules of the charter. When I read this, it's like the mayor or the city manager can place items on the agenda, and a council member may require any item related to city business to be placed on an agenda, for which notice may be given. So, yeah, that'd be like one city council member.
Correct.
Why can't I, if I was,
So-
One city council member can place items on the agenda. They just have rules around how they're placed and when they can and how many they can place at a time, yes, and when they can place them.
But do those rules comply with our charter?
I would argue that city council has the authority to create their own rules
Oh.
of procedure, and this is a procedural rule.
So
there's no
they
limitation
can like
to-
create their own rules on how to interpret the charter.
Not on
I
how to
think we're
interpret
getting
the
on a
charter.
slippery slope
This is
here.
on procedure, so the procedure to how to place the item on the agenda.
It's an agenda. It's pretty simple.
I think the some of past history has been certain council members putting multiple things on the agenda.
Right?
And so the rules of council was to limit the amount of items a particular council member could place. But we don't want to take the right of a council member being able to put something on the agenda. Is that what you're saying?
Yeah, I think that has in the past been done.
I think it's more of a limit of, again, how many items you place on a single agenda, not that you can't place that item on a future agenda. It's more of an efficiency issue than a charter issue, in my opinion.
Okay, because it's my understanding the rules of council is 3 items per council meeting. Is that right?
It's, I think, 2 and then 2 proclamations, or 2 and then 2 reports. I can't remember exactly off the top of my head. And I don't have my computer with me, I'm sorry.
Okay.
I've heard councilmen mention the number 3, but I don't know what mix of those it is.
It's somehow gets to 4, but I think you have to have a co-sponsor on either 1 or 2 of them.
Okay.
But it doesn't mention a co-sponsor in the charter.
No, again, this is more, from my perspective, this is more of an efficiency issue on the procedure of how you can do it. It's not that you can't place that item on a future agenda, it's that it's an efficiency, a matter of how many items you can place on each agenda and how to place them on there.
Well, if you want to like make it an efficient way to run a meeting, just put a timeline on when the meeting's cut off.
11 PM is late enough. If we start letting them put more on there for any specific council meeting,
There are actually
We do-
charters that do exactly what Ms. Knight just recommended. In fact, my previous city, the charter said no meeting shall continue past midnight. And at midnight,
I
you would have
like
to
that.
stop and come back the next day.
I like that.
I'm not saying that's a great idea. Those meetings started at 11:30 a.m. and our meetings start at 7 p.m. So there's a huge difference between what midnight was to them and what midnight is to us.
oh my gosh.
Yeah, I mean, at the same token, are those full-time positions?
Those council members?
Yeah,
No, not necessarily.
but they could be.
They could be. It depends on your perspective. I'm not saying that's a requirement. It's something that we should do. I'm just saying there are cities who do it. There are cities who do all sorts of interesting things with charters, and we can investigate any of them that you're interested in.
So if I was a council member, and they do this special meeting before the regular council meeting, can I
Yes.
put 3 items on each?
They discussed that the last time they discussed the rules, and they determined it was the same, the number was total for that day. So you can put on it any combination of special or regular at that day. So the special
Oh, that
meeting is
day.
typically just the
Okay.
closed sessions, and so typically items that get added to the closed session go through myself and the city manager before they get put on that agenda.
Okay. Commissioner Knight.
So, the mayor has no limit in the number of agenda items. But according to our charter, we're, city manager council form of government, correct?
Mhm.
So, why is the mayor unlimited, but the council are not? The mayor only gets one vote.
Can I give you the reasoning for why they did this? No. From my perspective, the mayor has the power to control the agenda. That's written right here. The mayor or city manager shall approve meeting agendas. He has a power to control the agenda in a way that other council members do not. That's just my perspective on
I
it.
know, I know, it just causes problems.
I would add that when we get to Article 4, there's a definition of the mayor and his authority and limitations, and his is different than the other city council members. There's got to be somebody in charge.
The mayor, like Diane, is the chair of the meeting. That's what he does. And he cuts ribbons at ribbon cuttings. He has no more power than any other city council member.
We can discuss that at the next meeting in Article 4, but he does have different responsibilities in Article 4. Is this something we want to give additional thought, or do we want to leave it the same, or?
Between the
Recommend
3.07 and the rules that were displayed a minute ago, I'm fine with leaving it as is.
Anybody else got any other thoughts? No?
What are we on right now?
Section 3.07.
Okay, no.
You good?
Yeah.
Commissioner Ford?
I don't have any further recommendations.
I'll give it up.
You'll give it up?
Okay. And that brings us to 3.09.
Compensation.
3.09 is compensation for city council. I've pointed out that it exists. There are a few things that you might want to consider. I do not make recommendations on compensation of city council, so this is something for you guys to discuss. If you have any questions, please let me know. Oh, and I do want to note that the time in which the city may appoint a compensation committee overlaps with the time that this commission is working, so it is possible that they could be going at the same time. There's actually an item on the, probably coming up on an agenda pretty soon to discuss whether or not they want to appoint a compensation committee.
Commissioner Ford?
Would it be effective or efficient for us to make discussion on this only for it to be undone or anything like that by a compensation committee?
So the really interesting thing about overlapping is the compensation committee would make their recommendation for the budget. You would make your recommendation for a charter election in November. So those are different things, and if you changed the charter, that charter change would go into effect upon the vote if it passed. And so the compensation committee would finish their work, council would approve the budget, and then potentially something could change in the charter. I'm not recommending that. I'm simply saying that's how it would work.
Commissioner Knight?
Yeah, the only thing I would say is that I know from, I guess it was the last compensation committee, there, and just from city council talks, there was a lot of discussion on whether what they were getting was a salary or a stipend or, you know, I would think that perhaps if we could nail that down a little bit more in the city charter, because apparently that makes a difference I mean, here it's like salary, salary, salary. And, is it a salary, which would like probably come with benefits, correct?
Not necessarily.
What about stipend?
The stipend is typically to reimburse sort of out-of-pocket costs related to position. Not always. Sometimes it's, a benefit for doing additional work. It just depends on the circumstances.
An honorarium?
An sort of an honorarium. Compensation or a salary doesn't necessarily entitle someone to benefits. Typically, if you work part-time, you don't get full benefits at your position, depending on the company and the employer. Now, state law authorizes a city to allow their council members to participate in an insurance program or other benefit on the same terms as full-time employees. That is authorized under state law, and that is separate from salary.
Anybody? Commissioner Ford.
My feeling is that if the job of a city council member is such that it pretty much constitutes a full-time job, and of course there would need to be, documentation proving that, I suppose, but if they are working full-time hours, essentially, I don't think it's unreasonable to allow them a salary of what would be considered a full-time employee, and that would include benefits as well. They should be compensated for time and labor put in just as any other employee or worker might have.
Commissioner Knight.
I agree with Hannah, but I think we need to pin down exactly what it's called. And if they are getting a salary, they probably should not be having a second job. It's hard to work 2 jobs in 1 week.
Commissioner Ford.
You can, but it's not preferable. You can't burn the candle from both ends, as they say. So if we want high-quality council members, I think that, yes, there's the argument that people may only be here for the paycheck. However, if you compensate them fairly, it would encourage a higher quality candidate.
My thought is that unless and until we make it such that they cannot have a second job, the fact that they can is part and parcel of the benefit of having the job. Most city business isn't done on weekends. For example, if they have the ability to have another job, I don't think we need to go above and beyond. Now, if we change that, I do agree with you, right? If they're prohibited from having another job, that would warrant more benefits, but as long as they're entitled to do that, allowed to do that, willing and or able to do that, I don't think we should go beyond it.
How would you enforce someone from taking on a second job?
Time sheet?
So, as a full-time city employee, I am subject to the city's personnel policies, which require me to get approval for any outside employment. So I'm a full-time city employee. If I want to work a part-time job or a full-time second job, I have to get approval.
Yeah, but who's the judge of the city council?
City council. We just talked
The
about that
council
provision.
members?
I'm okay.
I'm not advocating for doing that to council. I'm just saying that's how a company or the city as an entity could enforce that, is you could put it in a policy. There's a lot of different thoughts on how to compensate city council. Everybody does it differently, and I don't know what the right answer is here, and I wouldn't make recommendations on it.
Okay. I'm okay with leaving section 3.09 as it is. Commissioner Knight.
Can we bring it back
Sure. Anybody have
for
any
some
objection?
further discussion?
I have some questions for,
Go ahead, Commissioner.
so I noticed in your note, you say some considerations include when an absence should necessitate forfeiting of salary. It says in here that if they miss a meeting, they're not to be paid for that meeting.
For that meeting, correct.
So is that not being done? Or is there someone who's tracking that Bob's not making it to the city council meeting, but yet he's getting his full salary / stipend, whatever we're gonna call it?
If they miss a council meeting and they don't have an excuse that's excused by council, they are not compensated.
Okay.
The question I have is whether we want to limit that to just regular meetings, whether we want to allow it to apply to special meetings, special called meetings, workshops. It's currently,
Well, if they're getting, in my opinion.
it's currently unclear in my
I'm sorry,
opinion.
didn't mean to interrupt you.
No, that's just my opinion. I would
Okay.
like to clarify the bounds around it.
Okay, well, in my opinion, if they're getting paid to do a job, and that job requires you to attend 6 meetings, then you need to be at 6 meetings. That's the way I feel about it. I have a lot of problems with salary for city council. Of course, I sat on the city council years ago when we were not paid, so I have some different feelings about pay for city council and for politicians in general. But if that's the requirement of your job and you are being paid, then if we have 8 meetings, then you better be at 8 meetings. If you're not at 8 meetings, you're gonna get paid for the meetings you were at.
And does that
So-
allow for exceptions due to
Well,
illness, sickness?
Yeah, I could go for that, right? I mean, if you just haphazardly didn't wanna go that day, no, you don't need to be paid. But if you have a legitimate reason, I'm okay with that.
Like as excused by counsel or something like
Sure,
that?
sure.
I
Commissioner
think
Ford.
it would go back to the list that we are allegedly making of the justifiable cause, sufficient cause. The same thing could apply.
One other question, I'm sorry. So it states in here that reimbursement for all necessary and approved expenses incurred in the performance of their official duties. Sorry, they're entitled to, I didn't read the entire sentence, sorry. My understanding is that they have company cards, city credit cards.
They do currently, yes.
So that's not a reimbursement, then they're actually making purchases with a credit card. Is there some type of procedure that they've got to go through to validate that
Oh,
the
yes.
charges that
That-
Stewart put on there are legitimate charges?
That was discussed very frequently over the summer. They have a policy on how they can use their credit cards, what documentation they need to provide. If they don't provide the documentation, the charge is deducted from their salary.
Okay, then do we need to change this language because this is a reimbursement? And if I'm using a company credit card and it's deemed by my employer that charge wasn't acceptable, I'm paying him back. So there isn't a reimbursement to me. I'm reimbursing because I
if-
put an invalid charge on my corporate card.
If you're gonna change it, I would recommend adding flexibility as opposed to wholesale changing it, because in the future, say they don't want, the policy changes and we don't do credit cards anymore, we don't wanna have to change the charter. So
Okay.
perhaps, some more
Just tweak
flexible
it-
language on
tweak
how
it
they can
some-
get
okay.
reimbursed or pay through credit card, either way.
All right, thank you.
Could just add something like, shall also be entitled to reimbursement or allowance for all necessary and approved expenses.
Yeah, something along those lines.
Also,
We can
one
move forward
thing
with it.
in regard to the reference back to the missing meetings thing too, we could simply add towards the end, in accordance with section 3.07, if we're going to add a
For-
non-exclusive list.
For good reason, in accordance,
Yeah,
as defined or whatever in that section.
I'm sorry, 3.06, yeah. And that's one way to maintain consistency, is as opposed to writing something here and writing something else there. Over here, we just say, see there.
Commissioner Knight.
And I actually have a question for Commissioner Glickler. It's sort of a legal question.
She's the attorney.
She's my attorney.
He's not.
I'm here, I'm a private citizen.
I've known him. long.
She knows my background. Go on.
It says members of the city council shall also be entitled to reimbursement. So shall means you'll get it, right?
Right, but it's qualified, right, but it's qualified by necessary and approved.
Correct.
So if it's deemed not necessary
And
or
that-
deemed unapproved,
The way this provision works is they basically approve what can and can't be reimbursable in the budget or through policy. And if it qualifies, then it can be reimbursed.
and I'll add, to what Commissioner Kirkwood said, that part about forfeiting there is no qualification here. They shall forfeit the amount if they miss the meeting. There is no qualification at the moment. Which is why I suggest referencing back to 3.06, because then that's how we work the good and sufficient cause into this paragraph.
Any other comments?
Okay, your statement about the assistants. I know by talking to a couple of councilmen, what they do is they get the agenda on Friday, they peruse it over the weekend, then they start hitting city staff and saying, what about this, what about this, what about this? Would giving them an aid of some kind assist city staff? Do they get overburdened with any of these requests from city council?
I mean, I don't know that giving them an aid, I'm not really sure what an aid for city council would do. We haven't had one here because this charter prohibits it.
Right.
Yeah.
And I do think that removing the prohibition from the charter would not necessarily mean that they would get an aid. So it's not like a guarantee. I will say, yes, there are some things that city staff does at the request of council. Typically, those requests go through the city manager, as is generally required in a council manager form of government. You make the request to city manager passes it on to staff. There are some things that city staff will do on their behalf, such as, if they're traveling for city business, city staff might book the flight or the hotel or something involved in that perhaps if they had an aid, that aid could do. I don't know how much of an impact that would have on staff time.
But that's staff, that's part of their normal duties in a day, right? That means
Right.
that in addition to my normal duties, I'm gonna help Councilmember Bob out when he has a question, right?
Right.
Yeah, I'm okay with that, but I'm totally opposed about hiring another employee just to babysit these council members. That I cannot, I can't go there, so.
I agree with you completely, because the other factor is too, that city staff, there's a chains of command and whatnot, and yes, while it does ultimately end at the city council, I mean, if there's a check and balance there, that would disappear if we changed and allowed a staff member for a council member, is my opinion.
Commissioner Ford?
I agree. I don't think that an aid is necessary. That would be potentially removing some of council's responsibilities, which would then necessitate a decrease of their compensation.
I have no issue with leaving it as it is. I just wanted to ask the question because, I don't know that this is only one, well, I said it was two. There's one council member that's doing this, and I was just wondering how much, if all of them are hitting city staff on Monday, with questions so they can be ready for Tuesday. And again, I know not all city council does this. I've sat in here enough to realize that.
Well, the true aid is, as Amy referenced, is the city manager. The city manager should be the one that's getting hit with all their questions, and then he disseminates it to the city staff. So, yeah, I think the city manager gets paid well.
Yeah.
Anyway. Any other comments? Nope. All right. I think we've gone over all the sections that are on the agenda for this evening. Moving on to item number 5. We do have a public hearing, and that public hearing is put on here just as a agenda item because we're going to have it every time.
Yes, it's on every time, so that anytime the public hears something that we say during this, they can come and speak if they wish to.
Okay. And then item
We do
number.
have to open the public hearing even though there's no public in the audience. If you could open.
Oh,
and close it.
okay. It is 7:55, and I will open the public hearing for the Charter Review Commission. Would any citizens like to speak? Seeing none, I will close the public hearing at 7:55. Okay. And then moving on to item number 6, consider possible action. I don't think we're ready for that one yet, are we?
You don't have to make any votes today. We can take the notes on, Jennifer's been taking notes on what we've discussed. We can put that together, bring you some options next meeting.
So what y'all prefer? Yep.
I move to table till the next meeting.
We don't even have to table it. It's
Alright.
just to take action if you choose to.
I think it makes sense to do it at the next meeting.
We
Because
were, we were just trying to create a standard agenda so that we're all used to what we're seeing.
yeah, the next few sections are going to be a little bit meatier, so, and this is going to take a little time as well, so I think we should save it for the next meeting.
Okay.
Okay, we agreed the next meeting will be on February 24th.
Should be 2 weeks from today.
Okay.
And Madam Chair, what's our homework for that?
I'm, sections 4, 5, and 6.
Thank you, ma'am.
Okay?
Whoa.
I think at a minimum, I think at a maximum, 4 and 5. If you look, we just went through 3 pages tonight, and sections 4 and 5 will be 4 pages, and then we're gonna get to initiative, referendum, and recall, and that's,
I can post 4, 5, and 6, but only put my presentation on 4 and 5, and that way if we move really fast, we can talk about 6.
okay.
Okay.
'Cause
Let's-
at this point, we have 10 sections left.
Right.
Okay. That's good. Okay. All right. Do I hear a motion to adjourn?
Motion to adjourn.
Second.
It's 7:50,
Sorry.
okay, 7:58 or whatever. Okay, thank you.